Hi, what if I told you that in a Florida custody case, the judge isn't just deciding who's going to get the kids? They're deciding what kind of childhood your child is going to have. Every single decision a Florida family court makes about your child comes down to one standard, and that's the best interest of the child. And if you don't know what that actually means, what a judge is actually looking for, you could walk into that courtroom completely blindsided. So today, we're going to break it all down factor by factor with real world examples so you can actually understand what is at stake. My name is Sarah, and I am a family law attorney in Florida. And on this channel, I break down family law topics in plain language so you actually understand what's going on in your case. If you're going through a divorce, a paternity case, or any custody situation in Florida, this video is for you. Now, make sure you stick around because we're going to go through all 20 factors the court considers. And trust me, some of them might surprise you. This video is for informational purposes only, and it does not constitute legal advice. Please consult a licensed Florida attorney for advice specific to your situation, because every case is different. So first, what even are these factors and why do they matter? Well, in Florida, anytime a court is making a decision about a child, whether that's crafting a parenting plan, a time-sharing schedule, or parental responsibility, the judge has one job: figure out what's in the best interest of that child. Now, the Florida legislature actually wrote out a specific list of 20 factors that judges are required to consider. And these factors live in Florida Statute 6113, subsection 3. This is the roadmap the court uses every single time custody is at issue. Now, here's something really important to understand, okay? Florida now starts from the presumption that equal time sharing, meaning a 50-50 split, is in the child's best interest. So if you want something different from that, you or the other parent has to prove to the court why equal time wouldn't work for your child. And when a judge decides to give one parent more time than the other, they have to go through these 20 factors and explain in writing exactly why they made that call. So whether you're the parent asking for more time or you're trying to protect your child, knowing these factors is essential. Let's go through each one, and I'm going to read you the language from the statute and then break it down with real world examples. Factor A. This part of the statute reads: the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. So in plain terms, this factor is asking, does each parent actually support the child's relationship with the other parent? Do they show up for exchanges? Do they respect the schedule and act like an adult when life requires flexibility? Example 1. Mom consistently makes negative comments about dad in front of the kids, refuses to swap weekends, even in an emergency, and blocks dad's calls during her time. That's a direct hit on this factor. Example 2. Dad always encourages the kids to call mom. He's never missed a pickup, and when mom needed to swap a weekend for a work trip, he said, no problem. Now that dad is going to look great under this factor. Example 3. One parent files repeated false DCF reports to interfere with the other parent's time. Courts see through this quickly, and it can seriously backfire. So don't do it. Factor B. The anticipated division of parental responsibilities after the litigation, including the extent to which parental responsibilities will be delegated to third parties. Now, this one is actually about who's going to be doing the day-to-day parenting going forward. Will one parent be handing off a lot of responsibilities to a nanny or a grandparent or a new partner? Example 1. A parent is requesting 70% of the time sharing, but works 60-hour weeks and plans to have the child with a babysitter most of the time. Now, the court is going to question whether that's truly in the child's best interest. Example 2. A parent works a standard schedule with structured after-school care in place and a grandparent nearby as reliable backup. Now, that's a clear, thoughtful plan. Example 3. A new partner is essentially acting as the primary caregiver during a parent's time sharing. This happens a lot. The court will want to understand that dynamic and whether it's truly serving the child. Factor C, the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. Now, the court is looking at whether each parent actually makes decisions based on what the child needs or what the parent wants. Example 1, a parent refuses to allow the child to attend an important school event because it falls on their time, even though the child really wants to go. That's prioritizing a personal control over the needs of the child. Example 2, a parent voluntarily adjusts their schedule so the child can attend both parents' holiday celebrations because it makes the child happy. That's exactly what this factor is looking for. Example 3, a parent drags the child to every court-related appointment and lets them overhear adult conversations and arguments about the case. Now that's putting the parent's need to win above the child's emotional well-being. Factor D, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. How long has the child been in a stable, consistent situation? Courts are very reluctant to uproot a child who is thriving. So, example 1 could be the child has lived in the same house, gone to the same school, and had the same routine for 5 years. The court will weigh that stability heavily. Example 2, a parent has moved 3 times in 2 years, changed the child's school twice. That instability is going to be a real concern for the court. Factor E, the geographic viability of the parenting plan, with special attention paid to the needs of school-aged children and the amount of time to be spent traveling to effectuate the parenting plan. This factor doesn't create a presumption for or against relocation. Is the proposed parenting plan actually realistic given where the parents live? Example 1, parents live 50 minutes apart. Week on, week off schedule makes total sense and is easy on the child. Example 2, parents live 2 hours apart. A 50-50 schedule might work in the summer, but it's probably not practical during the school year if it means the child is constantly in the car. Example 3, one parent wants to move to another part of Florida. Now, the court is going to consider how that affects the logistics of the plan. Factor F, the moral fitness of the parents. Now, this one sounds intense, but the courts are really focused on whether a parent's behavior directly impacts the child, not on judging parents as people in the abstract. Example 1, a parent is having an affair. On its own, that generally won't affect the custody outcome unless the child was exposed to the situation in a harmful way. Example 2, parent brings different romantic partners around the child frequently in ways that cause confusion or emotional distress. Now, there's an argument that it's affecting the child, and then this factor becomes more relevant. Example 3 would be a parent openly engages in substance use and allows the child to witness it. Now, that's going to implicate both this factor and factor Q, which we'll get to. Factor G, the mental and physical health of the parents. Now, the court is going to look at each parent's mental and physical health, but this is not an automatic disqualifier. So, one example might be a parent has been diagnosed with depression and is actively treating it with therapy. They're stable and they're present. Now, that's very different from someone whose untreated mental health struggles create an unsafe home. Now, example 2 would be if a parent has a physical disability that limits their mobility. The court is going to look at whether it actually prevents them from safely caring for the child, not just whether the condition exists. Example 3, a parent went through a difficult mental health period, but has documentation showing treatment, improvement, and stability. Courts respond to evidence of genuine effort and progress. Factor H, the home, school, and community record of the child. This factor looks at how the child is actually doing, school, at home, and in their community. It's a window into whether the current arrangement is working. Example 1 would be the child is thriving, good grades, active in sports, strong friendships. That tells the court the current situation is working. Example 2, since the separation, the child's grades have dropped. Teachers are reporting behavioral issues. That signals something needs to change. Example 3, one parent is actively involved in the child's school, attending conferences, volunteering, while the other has never attended a single school event. The court absolutely notices that. Factor I, the reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. If a child is old enough and mature enough, the court can consider their preference. But I want to be really clear here. No judge is going to let a child decide where they live. That is not the only thing that they're going to consider. Example 1. A 15-year-old expresses a thoughtful and well-reasoned preference to primarily live with one parent due to school, friends, and activities nearby. A judge would take that more seriously than, let's say, a 7-year-old says they want to live with dad because he lets me stay up late. That's not going to move the needle much. Example 3 would have to do with maybe a parent coaches the child on what to say. Judges and guardian ad litems are very experienced at detecting coached responses, and it can seriously backfire on the parent who did it. So don't do it. Factor J, the demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. Now, does each parent actually know what's going on in their child's life day to day? That's what this factor is all about. Example 1. One parent can name the child's teacher, best friend, pediatrician, favorite after-school activity. The other parent doesn't even know the name of their school. That contrast matters. Example 2. A parent who travels frequently for work but makes consistent efforts to stay connected. Calls at bedtime, knows the child's schedule, meets with teachers if necessary. That can still demonstrate a meaningful involvement. Example 3, a parent who has been largely absent and now claiming they want 50-50 time, but can't answer basic questions about the child's life is going to have a hard time with this factor. Factor K, the demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. This factor is about structure. Does each parent maintain a consistent, reliable routine for the child? Example 1, one parent has a clear daily schedule. Homework right after school, dinner at a set consistent time, bedtime always at 8 o'clock. This structure gives a child security. Now, example 2 would be during one parent's time, the child stays up until midnight, skips meals, has no homework routine. Teachers notice the child is tired and unprepared when they go to school the next day. That's going to reflect poorly. Factor L, the demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. Co-parenting communication matters a lot. Can these two parents actually communicate and present a consistent front to their child? Example 1, one parent never tells the other about the child's doctor appointments, school issues, or schedule changes. The other parent then finds out this information from the child. That is a problem. Example 2, both parents use a co-parenting app to share schedules, medical updates, and school information, even though they don't get along. That's exactly what the court wants to see. Example 3, the parents disagree on discipline at home, and one parent undermines the other's rules constantly in front of the child. Now, that lack of a unified front is harmful to the child and is relevant to this factor. Factor M, evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, regardless of whether a prior or pending action relating to those issues has been brought. If the court accepts evidence of prior or pending actions regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect, the court must specifically acknowledge in writing that such evidence was considered when evaluating the best interest of the child. This is one of the most heavily weighed factors. When there is evidence of domestic violence, abuse, or neglect, everything else becomes secondary. Example 1 would be there is a documented history of domestic violence with police reports, prior injunctions, and medical records. The court must factor that in and specifically note in its written order that it was considered. Example 2 would be if a child discloses abuse to a teacher that then leads to a DCF investigation. Even if no criminal charges follow, the court will weigh that evidence in the custody determination. Example 3. Notice that the statute says regardless of whether a prior pending action has been brought. That means even if there was never an arrest, never a protective order, if there's evidence, the court can still consider it. Factor N. Evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. This factor is a serious one that people don't always expect to see on the list, but if a parent lies to the court about abuse, violence, or neglect, that itself is a factor that goes against them. So, example 1. A parent claims there is no history of domestic violence, but records show that there was a prior injunction. Knowingly misrepresenting that to the court is going to be damaging. Example 2. A parent fabricates abuse allegations against the other parent as a litigation strategy. If the court finds out, and courts often do, this factor will be used directly against them. Example 3. A parent fails to disclose a prior DCF case in another county. When it comes to light, the court views the omission as knowingly providing false or incomplete information. So keep that in mind. Factor O. The particular parenting task customarily performed by each parent and the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. Who has actually been doing the parenting? Not who wants to, who actually has been. Example 1. For years, mom handled school drop-offs, doctor appointments, homework, and bedtime routines. If she requests primary time sharing, that history supports her position. Example 2. Dad worked long hours and was largely absent during the child's early years, but now he wants 50-50. The court is going to look at whether there's been a genuine, sustained shift in his involvement, not just a recent change motivated by the litigation. Example 3. During the pending litigation, one parent suddenly becomes very involved to build a record. Courts see that. Consistent long-term involvement carries far more weight than a sudden surge right before a hearing. Factor P. The demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. This factor is about showing up, not just financially, but physically and emotionally for the child's school and activities. Example 1. One parent attends every parent-teacher conference, coaches a soccer team, volunteers at school events. The other has never set foot in the school. That is a significant difference, okay? Example 2, a parent who works a demanding job, but still makes it to performances, games, and school events whenever possible. That is a parent that's demonstrating the capacity and disposition for what the statute is calling for. Example 3, a parent signs the child up for extracurricular activities, but never attends a single event. Enrollment alone doesn't show involvement. Presence does. Factor Q, the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. Substance abuse is taken very seriously. The court wants to know, is this home a safe environment free from the effects of drug and alcohol abuse? Example 1, a parent has a documented history of alcohol abuse, including a DUI. Without evidence of treatment and sustained sobriety, the court is likely going to limit or supervise that time sharing. Example 2, a parent is in active recovery, has been sober for 2 years, completes regular drug screens voluntarily, and has a strong support system in place. Now that tells a very different story from our first example. Example 3, a parent tests positive for substances during the course of the case. Depending upon what was found and the circumstances, that can result in supervised visitation or a significant reduction in time sharing. Factor R, the capacity and disposition of each parent to protect the child from the ongoing litigation as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. This one is huge. And this one also is one that parents don't consider all the time. You should not be involving your child in your case. Period. I don't care how old they are. I don't care how smart you think they are. They should not be involved. Example 1, a parent shows the child court documents, text from the other parent used as evidence, or videos of hearings. That is directly violating the spirit of this factor. Example 2, a parent vents to the child about what the other parent did or said, calls the other parent names, or tells the child, "Your dad is trying to take you away from me." That's disparaging language, and it hurts the child more than it hurts the other parent. Example 3, a parent keeps the child completely shielded from the litigation. They don't discuss hearings, they don't badmouth the other parent, and when the child asks questions, they give age-appropriate, neutral answers. That parent is protecting their child, and the court is going to recognize that. Factor S, the developmental stages and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. Does each parent understand what their child actually needs at their specific age and stage of development? And are they equipped to meet those needs? Example 1, a toddler needs frequent shorter contact with both parents rather than long stretches away from either one. A parent who understands that and proposes a developmentally appropriate plan shows a real awareness of what that child needs. Example 2, a teenager needs more autonomy and social time with peers. A parent trying to enforce rigid, isolating rules that aren't appropriate for a 16-year-old may not be attuned to where their child is developmentally. Example 3, a child needs therapy following a traumatic event. One parent facilitates it, engages with the therapist's recommendations. The other dismisses it and says, "Kids bounce back." The court is going to take note of who is actually responding to the child's developmental needs. Factor T, any other factor that is relevant to the determination of a specific parenting plan, including the time-sharing schedule. And finally, the catch-all. This factor ensures that a judge isn't boxed in by the first 19 factors. If something is relevant to what's best for this specific child and this specific family, the court can consider it. Example 1, a parent is in a relationship with someone who has a criminal history that may pose a risk to the child. Even if it doesn't fit neatly into another factor, the judge can weigh it here. Example 2, one parent is systematically cutting the child off from extended family, grandparents, aunts, uncles, who have always played an important role in the child's life. That relationship history can be raised under this factor. Example 3, a parent's job requires months of international travel with no reliable childcare plan in place. That reality can be raised and considered here, even if it doesn't fall squarely under another listed factor. Okay, I know that was a lot. 20 factors is genuinely a lot to take in. But here's what I want you to walk away with. These factors are not just legal boxes for a judge to check off. They are a window into what the court is watching for every single day of your case. How you communicate with your co-parent, how you show up for your child, how well you actually know your child, and whether you're protecting them from this process, which is a very big deal. The best thing you can do, regardless of where you are in your case, is to be the parent these factors describe. Document your involvement, show up consistently, know your child, keep your child out of adult conflict, and put your child first, not just when a judge is watching, but every single day. If you're going through a custody case in Florida and need guidance specific to your situation, please consult with a licensed Florida family law attorney who can advise you based on the facts of your case. If this video was helpful, please give it a thumbs up. It really does help this channel grow. Drop your questions in the comments below and make sure you subscribe so you don't miss the next one. Thank you so much for watching. I'll see you next time.